Okay, good afternoon. This is Special Education Thursday. I'm still Maria Blaeuer, your host here at AJE, and today we're going to talk about mediation. We've got two amazing guests to kind of walk through the process with families, and like I said, we're going to do mediation, Special Education Thursday, still not Molly Whalen, but you guys will all be okay without Molly. Hopefully she'll be back doing these soon. Okay? All right. First, I want to introduce our guests, but again, I'm supposed to tell you who I am. So I'm still Maria over here at AJE. I've been here for about 8 years. And before that, I was in private practice for about 10 years, working in DC, Maryland, and Virginia. I'm a big fan of mediation. I think it can be a really powerful tool. So I'm very excited to be part of this conversation today. I'm going to ask Tamiesha to go first, and then we'll hear from Bill.
Hi, everyone. My name is Tamiesha Lawrence. I am the parent support specialist with Advocates for Justice in Education. I also am the training and outreach specialist for parents of students with disabilities. Nice to meet everyone.
And good morning, everyone. My name is William Jaffe. I am an attorney and I represent parents in education and particularly special education matters in the District of Columbia.
Perfect. So we're just going to jump right into the meat of things. First of all, I guess the first question is, I'm going to throw this one to you, Bill. How do parents wind up in mediation? Like, how do we even get to this place where we're talking about how to prepare for mediation or what to expect at mediation? How do you get there?
Well, it's important to remember that mediation is voluntary, and so both sides have to agree. Mediation is almost always available, and particularly in the context of an IDEA or an education matter, mediation should always be available to you, although a parent might or might not know about that from the outset. And so if both sides agree, they can go to mediation. And it doesn't mean you give up anything. You can still have a hearing if the mediation doesn't work out the way you want it to. You can still have a hearing after mediation. And so sometimes a good thing to do is to file for a hearing. And while you're waiting for a hearing early in the process, see if you can start a mediation as well.
So that is definitely kind of the most popular and common way, I think, to get to mediation. One of the things that's unique about the district is you can also directly request mediation without having to file a due process. So there's two real ways to get there. You can go as a part of your dispute resolution. If you have filed a complaint, a due process complaint, and we have another video about that process, so we're not going to worry about that today. Or you can just directly request mediation. I think it's really important to remember that what we just heard, that everybody has to agree to it. Yeah. So Tamiesha, is there anything else you wanted to add about what mediation is? I know you're a parent, you've kind of gone through this process together,
Well, in my experience, I actually suggested it one time. And so I felt like when it was accepted, I felt really inclusive and, what the next steps were going to be. And so if you're looking for a space of empowerment, suggesting mediation, I felt like was a stepping stone for that for me. Like when you feel like you're arguing all the time and you go to someone and say, hey, can we just work it out with a third party so that we can be, both being that person can be impartial and work it out together. I felt like it was an empowering moment for me when it was accepted.
Oh, and she just like slid right into the next question. You like that? What is mediation exactly? So you hit the high points. We've got a third party neutral. It's a conversation. It's confidential. Anything you want to add to that? Bill, this one's for you. So anything you want to add?
I'm sorry.
That's okay.
No, I think you are going to get, in the context of a special ed mediation, you're going to get a hearing officer, but it won't be the hearing officer that you'll have assigned at your hearing. So it really is, a chance to work with a different party. And the goal is to, as Tamiesha said, is to reach an agreement. And so there can be like a whole separate energy involved in a mediation, whereas, a hearing is with fighting and each side trying to, one up the other side. Mediation should be, ideally should be kind of a different experience, trying to find common ground.
And that's a good point. You, in the district, you have mediators who are coming from your hearing officer corps. So they both have training in actual mediation, but they know the subject. They're subject matter experts, which I think makes a big difference, having gone to mediation for special education cases with someone who didn't know a lot about special education. It's very nice to have somebody who knows about it. So who's in charge of it? This is run out of the same office that handles everything else, dispute resolution, which is the Office for Dispute Resolution within OSSI.
Right.
Yeah. And they're the ones who are assigning hearing officers and assigning mediators. And then there's this other thing we have in the district that I just like to clarify for families, that we do have the Ombudsman's office. That's part of the State Board of Education's offices, and they offer something like mediation for families. That's not what we're talking about today. We're really focusing on that IDEA, dispute resolution, mediation in that context. But I did want to flag that it's out there and that exists. All right, so before we pop over to the nitty-gritty of mediation, anyone want to add? Nope, feeling good?
Yep.
All right. Okay, so you show up, you've got mediation Tuesday at 2. What should you expect the day of?
Well, mediation is going to be, well, now mediation is all over Zoom. So you'll be, at home over Zoom. The other side will be in their office, and the mediator will be in a third location. You'll all be meeting remotely like we're meeting today.
And do you start together with both sides in the mediator? Is there any kind of pre-work that maybe you did before the mediation?
So I'm going to talk about preparation. Should I talk about preparation now? Okay. So I've got very definite thoughts about preparing for mediation. I think that a lot of the work for mediation can happen ahead of time. And if you have an attorney, it's obviously helpful to have an attorney. If you do have an attorney, although you don't have to have one, but if you do have an attorney, you should be talking with the attorney ahead of the day of the mediation. You should be working out, what your opening position is, what you want to get out of it, what your bottom line is, of course. And then there's a lot of specific ideas that I have about mediation that I want to share with you. One thing that's important to remember in mediation is it's important to be flexible. People get locked into positions, and one of the difficulties in negotiation, excuse me, one of the difficulties in negotiation is that people focus on their positions instead of their interests. So, for instance, an interest of a parent and a school, they do have a shared interest, which is moving this student forward. Both sides want that. Now, where they're stuck is they're stuck on how to do it. That's their position, but they have a shared interest. So if you focus more on your shared interests and don't get totally wrapped up and stuck on your positions, you'll be able to move forward. You can meet with your attorney, of course, in advance. You can also meet with the mediator in advance. And so you can do some of the work of mediation in advance. You can say, I'd love to have a chance to speak with you, Mr. or Ms. Mediator, ahead of time. And let's pick a time to do that. We can go over, what my concerns are, what my, I wouldn't sort of necessarily share everything with the mediator. You wouldn't want to say, well, this is my bottom line, because then the mediator might say, well, this is their bottom line. You don't want to do that. But you do want to sort of give the mediator a lot of information about your position so that they can help advocate on your behalf. They have to know the strength of your case, and that is, and the strength of one's case, of course, is always in the details. Well, I met with the school. I told them this ahead of time, they ignored me, and then this happened. You know, I gave this notice ahead of time. Here's the email that I gave them ahead of time to show them that they had notice. If the more the mediator knows about these essential facts of your position, the more the mediator can advocate for you. So preparation and possibly meeting with the mediator ahead of time, I think, is extremely important.
I really like,
Yeah.
I'm gonna pause you for 1 second. I'll let you get back to your, I sense a list, and I'll let you get back to the list, I promise. I think you made a really good point about, one, the possibility of talking to the mediator beforehand, right? The importance of flexibility, right? I think one of the things I really like about mediation is it lets you look at, talk about, and think about the problem holistically in a way that you really kind of struggle to do sometimes at due process, right? At due process, you've got to, you've got a burden, you've got elements, and that's a little different. Mediation is a chance to really look at the whole problem, and sort of figure out, okay, what's a good solution, what's viable. I always like to think of it as an opportunity to explain to the mediator, like how we got here, right? Like what happened that brought us to this place. Was there anything about preparation, Tamiesha, that surprised you, or that you were like, oh, this is different?
I think I would say my first experience regarding mediation probably wasn't the same. Like when I had that there, like I kind of went into it with one idea and then came out with a completely different, but the preparation wasn't as extensive as with the last time I did it, which made, I like the secondary preparation because I understood more like what was going on and the impact that I had on the actual mediation. So understanding that you have a lot of, like, it's not just a bunch of people sitting around you telling you how it works. Like they really do come to you to see what it is that you want and what you're looking for. And then the attorney there helping you saying, hey, well, this is what is kind of realistic for this situation. I know, like you said, what was your statement, Bill? It was um how you determine like what you're going in with and what you're gonna come out with. It was how you separated. I'm sorry, I don't want to mix it up. It was something you said in the beginning about interest versus.
Oh, interests versus positions.
Okay, so yeah, interest versus positions. And so explaining that to me at the time before the meeting really helped because naturally people don't know mediation is just that, is literally compromising. It's not fighting like
Right.
some parents who have children with disabilities are used to doing. So going in and understanding what your interest is or what the child's best interest is versus your own or versus the position like you're in saying, oh, I'm upset because of this, or I'm upset because that doesn't matter. You're trying to come to a mediation conclusion compromise thing.
Okay. So and I'll let you get back to your preparation list in just 1 second. We've definitely covered, can you talk to the mediator without the school present? Definitely. We've talked a little bit about what the mediator does. And we'll, I think, loop back to that in a minute. But what other things do you need to do to prepare for a successful mediation in your mind, Bill?
Well, I think you really have to know your case. So, if you have an attorney who helped you prepare a complaint, you want to go over the elements of your complaint. So you want to make sure you don't forget any of the elements of your case, of your claim. So you want to make sure you're very familiar with the elements of your case so that you don't miss anything. Secondly, you want to marshal your evidence and you want to share it with the mediator. You can tell the mediator, look, I'm not in a position to share everything with the other side because there's no discovery in these cases. So, you don't necessarily want to give the other side the benefit of knowing everything about your case, all the details, but you can share it with the mediator. You can say, this is just for you. I'm going to tell you this. You can tell the other side this much, or you can tell them this, but not this. So you can sort of, parcel it out that way. But the mediator should know, at least on a confidential basis, the strength of your case. Do you folks agree with that?
Oh, Completely, and I wanted to add something. You said there's no discovery in these cases, and we have a rule at Special Education Thursday that we always try to explain, terms that might be unfamiliar or acronyms. Can you just briefly tell folks what discovery is and why it matters
Sure.
that you don't have it in special education litigation?
Sure. So in a court case, in a case, this is an administrative matter, but if you were in court, you would have a process after you file a complaint called discovery, where each side gets to ask written questions, ask for documents, and then they get to pose witnesses on the other side, asking them particular questions under oath, and the answers can be used at trial. So you don't have that. That's what that whole process is called, discovery. You don't have that in a special education case. So, you have to be more strategic about how you get the information and then how you disclose the information. And I'm not saying, everything is, very fact specific. You might do something one way in one case and a different way in a different case. But the mediator should be cognizant of the fact that this is confidential and you might not want to share everything with the other side. But with the mediator has to know the strength of your case. Otherwise, they're not going to be able to advocate for you.
And I think that the word confidential reminds me of two things that we need to talk about in relation to mediation, which is that everything in mediation is confidential. And usually, and what that means is that, the conversations you have at mediation can't become evidence elsewhere, which is key. And then whether or not the mediation agreement itself, which is kind of the end product of mediation, whether or not that's confidential is something that is negotiated between the sides, right? So I think we've done a lot of the preparation conversation. And then we've talked a little bit about what the mediator does. Is there anything else you want to add to that part?
I don't think so.
Okay. All right. So we've talked about preparation. We've talked about the process. We've talked about the benefits of it. One of the things I really like about mediation is that it brings in a chance to, I've already said, kind of look at the problem holistically, but it can also be a chance to kind of repair the relationship. People don't usually go to due process because everything's great and they're getting along. And mediation can be a chance to understand and talk to the other side in a way you really can't at an IEP meeting, because you have this mediator, this third party who's able to, sometimes translate, run interference, give people feedback on their positions. I know that, one thing a mediator may say to you in mediation is, yeah, I don't know if that's viable, or I think that's completely reasonable, which I think are both really good things about having a mediator who knows this content. Is there anything you want me to, is there anything any of you want to add before we
In
jump
terms
into
of preparing ahead of time?
In terms of preparing or the day of?
For the day of, no, I have a lot more to say about what should happen. You want me to tell you now?
I figured you did.
Okay.
So I think we feel pretty good about the day of, about preparation. Why don't we go ahead and jump into the day of mediation? I will tell folks my biggest tip for the day of mediation is to prepare yourself emotionally and physically. It is demanding. It is emotionally demanding for families. But also I think for attorneys who are doing the work, because it is a different kind of advocacy, right? You're looking at the problem a little bit differently. So I always tell folks, prepare yourself emotionally. This might take a long time. It can take half the day. I've done whole day mediations. Back when it was in person, I always used to tell folks, bring a granola bar, bring water. Now that we're online, less important, but I think the granola bar matters, because I will settle a lot of things real quick if I'm hungry. Yeah. So talk to us a little bit about the actual day of. Is there anything you want us to know there?
So I think it's very important, and what's worked for me repeatedly is to break into groups. And I propose just doing that right away, because as you both said, there have been meetings, You frequently know what the other side's position is. Now's the time to speak one-on-one, or your side and their side separately with the mediator. So I ask the mediator to just even to, sort of forego opening statements, because we basically know what each other's positions are, because we've already had a resolution meeting. So I'd like to go straight to talking to the mediator directly. And that may be a series of, it's sort of like shuttle diplomacy. So it might be a series of meetings. So, one meeting, but separate sub meetings. So you, as the petitioner, the parent as the petitioner, and the attorney will talk to the mediator first, say, and explain what they're looking for. Then the mediator will say, okay, well, now I've heard you. I kind of get an idea of what the lay of the land is. Then the mediator is going to go shuttle off and, put you in a waiting room and speak to the school system, and they'll do the same thing. And then the school system will go back into the waiting room, and then the mediator will come back and talk to the parent side again. And that may have to happen 2, 3, 4, 5 times. The other thing I like to do is I like to make sure before I speak to the mediator that my client is on board with whatever I'm about to say. So if the mediator suggests something, I won't react. I'll say, okay, interesting. Let me talk to my client for a moment, and then we'll go back into a waiting room. I'll get my client's approval or disagreement or whatever. The client will let me know, what's happening next. And then we can go back to the mediator and say, well, we agree to this, we disagree with that, and that's how we're going to move forward. And then the shuttle diplomacy continues. But you always want to be able to stop, talk to the client privately, and then go back and talk to the mediator.
So let
So
me
that's how.
kind of, oh, I'm sorry, let me jump in on something you said there, which I think is really important. My preference when I do mediations of any type is to be in the same room as my client, just because it's easier. And at this point, I think we all have Zoom fatigue. But I agree 100%. It is super, super important that you have a private, and I say this to people, so just for life, take this advice for life, not just for mediation. Super important that you have a private mode of communication between yourself and your attorney if you're in mediation, which is not the Zoom chat or the Teams chat that is provided by the Office for Dispute Resolution. You either want to be on the phone with them or talking to them in person or chatting. But I think having the ability to talk to whoever you're working with for the mediation is really, really important. So my preference is usually to do it in person with my, with my client in the office, just so, it's a little quicker and we don't always have to go off into Zoom rooms. But if you can't do that, just stay off that Zoom chat. That chat is not confidential for anything ever.
No.
Tamiesha, is there anything you want to add to that?
So I want to go back to the part about those meetings can be very long. And so if you have snacks, make sure you prepare with snacks, like have something to the side, water or something, because they can be very long, very, very long. And I don't know if the way that Bill is explaining it when it comes to like the breakout rooms, I don't know if that's what made it shorter, but one of the meetings I went to before had everyone in the room the whole time. I don't even remember if there was a breakout room. No, if there was a breakout room, it was when me and my attorney had to speak, but it was never like separate for us to talk. We stayed there the entire time, and it went on for like a whole hours. And so I would definitely suggest the opportunity to make sure that you have snacks to the side just in case it gets long. The other part that I wanted to add was where you are now in reference to like the connection with him coming back and forth and asking the client. That feels very inclusive. And so like it helps to feel like you have a say-so. I mean, you do have a say-so in it, but a lot of parents don't feel like it's their decision to come up with any ideas or any, just some things that would support their child better. And that's the time that to gather those, that's a good time to gather those notes before you come. what would be beneficial. They'll ask you specific question, like if you want tutoring or if you want a specific type of tutoring or something specific to assist your child with the things that you're working out, then make sure you ask those things and make sure your attorney is able to advocate for some of those things for you and have supporting information that supports why your child would benefit for those things, or whatever, just depending on whatever the situation is.
No, I like that point a lot. So we definitely hear, preparation pays off. We've heard a lot of back and forth. And we've heard there's, you're gonna have private one-off conversations, there's gonna be some shuttling. Is there anything else people should know about the day of?
I think so. I
Mhm.
think it's very important to be patient and to listen carefully to the other side, in this case, to the school system. At this point, there's litigation involved. Things are not going well for the child. Parents are angry, frustrated, and they have a right to be. But at this point, the parent is going to be better served by listening carefully to what the school system has to say, because it's that process of listening to the other side that will help draw both sides together. Some of this has to do more with negotiating face to face rather than in breakout rooms, but I want to include it anyway. It's very important to be respectful to the other side, because again, parent has every right to be angry, but this is not the time, this is not the day to show the anger. Revenge is the dish that's best served cold, and you catch more bees with honey than with vinegar. So, I always sort of like try to smile at the other side if I can, like pay them a compliment for something, if they've done anything right, try to do that. And then, in keeping with that, know when to bend so you don't break. So you have a bunch of demands. You're not going to get all of them, and if you give one of them up early, that may, sort of like develop a sense of good faith on the other side. And they may say, well, they gave up on that, so maybe we should give them this. That's sort of the give and take. The other thing that's very important is in negotiation is called something called BATNA, and I think it's your best alternative to a negotiated agreement. So know what your bottom line is. If you're not going to get there, make sure you can win at hearing, because if you can't win at hearing, then you don't have a better alternative to this. So you have to, that goes back to your preparation. You have to know, if this isn't going to work, what am I going to do instead? Well, that's going to be a hearing. If I'm going to have a hearing, do we have the evidence that we need to prove our case? And then finally, I think mediating early in the process is helpful, because you're not necessarily limited to just one mediation session. You could go as far as you can, with one, and then say, okay, well, you're going to stop now. We're not at an agreement, but we're going to stop and, maybe come back in a week. And you can do that if you've done it early, if you started the process early.
I think that's a really good point, particularly that you can go home, you don't necessarily, there is, I think, sometimes some pressure to resolve it today, right, from the mediator, because that's their job. And you don't have to. I mean, I think everybody kind of wants to do it. No one, everyone kind of wants to resolve it today, but sometimes you can't. And you don't have to. You don't have to sign the agreement that very day. You can take it home and think about it. And you can leave it open. I personally don't like to leave them open too long. But there is value sometimes in, stepping away, regrouping, and coming back. No, so I think that's a really good point.
I have another point, is that once well, I don't know, it may have to, my answer may be for the end. So do you talk about, we're talking, so I don't want to answer it. So wait, I'll wait.
Okay, we're getting there. We're getting real close to the end.
Okay, I'll wait, because it's something I want to talk about within the mediation, like when you're like something I want to make sure I add, because I don't want parents to not mention it. Okay.
So I loved the acronym you used, Bill. BATNA, which is best alternative to, remind me.
I think it's best alternative to a negotiated agreement. Maybe that's not exactly what it means, but that's the idea.
Okay. And that's, what's going to happen at hearing? What's the universe of possibility at hearing? And you want to keep that in mind as you're having these conversations with the mediator and the school. So anything else to think about for the day of?
I think to keep an open mind, realize that you do have a shared interest in moving the student forward, and to remember that you don't have to have all your eggs in the mediation basket.
And I think your point about sharing with the school, sharing with the mediator, hey, you can tell them, the first half of what I told you, but not the second half. I'm going to tell you, mediator X, Y, and Z, please only tell school X and Y. I think that's a really good point. And that's something the mediator can do. And I think it can be very powerful in moving you towards resolution. So we're coming up on the end, guys. What is one thing you want parents to know about mediation? So we've already talked a lot about snacks. That's my kind of favorite one thing. The other thing is there is a huge body of research over the last 40 years since IDEA has been around that tells us that when you go to any kind of dispute resolution, you're going to be more likely to go back to that level of dispute resolution. So once you go to due process once, you're more likely to go to due process a second time. And we also know that mediation just has, people, they have good outcomes. People report more satisfaction. They report not needing to access dispute resolution later. So I do think it is worth trying if it's a possibility for families. And I think it can be a very powerful tool to both resolve the current conflict, but also, start to repair that relationship, which I think is really important, even in a school, even in a jurisdiction like DC, where there's a chance to leave, your LEA and go to another LEA. We know that, educational stability is important and leads to, some good outcomes for kids. So those are kind of the things I want folks to know, is that it's worth it, and there's research supporting the fact that it's worth it. It's not just fluffy feel good. There's evidence for this. Bill, I'm going to let you jump in on this one, and then I'm going to let Tamiesha get the last word on what she wants parents to know about mediation.
Sure. I think one thing I would definitely advocate for is I would file a complaint first and get a hearing date, and then say, in addition to hearing, which is sometimes confusing for the Office of Dispute Resolution, so you have to be clear, I'm not giving up my hearing date. I'm planned to have a hearing if this doesn't work out, but I also want to try mediation. And I think having that hearing date set and in the background gives everyone a little more focus for the mediation. Whereas if you just do mediation, everyone might be a little too relaxed. So I think it's good to have a little sort of Damocles hanging over the school system's head.
I like that external pressure. All right, Tamiesha, here's your chance to make your pitch for mediation for parents. Go for it.
Okay. So my one thing that I want parents to pay close attention to is that when the mediation is completed and is printed, the standard time to complete the whatever you all have agreed to is a year. That's the standard time that they put on there. And if you're a busy mom like me who has multiple children and just multiple responsibilities all along, sometimes a year, and even the process of finding a good tutor or finding someone to implement the service that you're offered, or the, whatever you're offered in mediation, it's hard to find that. So I would request initially, if you can, to extend that time anywhere between 2 and 3 years from the date that you all sign it, because that is reasonable. A lot of and make sure that you have a copy of you need an authorization letter for everything that you agreed to in that meeting. You're not allowed to share your mediation agreement. And so because of that, you're going to have to prove that you have access to this funding or whatever resource that you've been provided. So my main focus is for you to get an authorization letter to make sure the time is where you can reasonably get all of the services implemented. And also it was one more thing, I can't think of it. And just, making sure that you're getting the services that you actually, are able to, like, it's reasonable for you to find services, like use a service, or that wasn't it. I just cannot think of what it is right this
Well,
second.
maybe one thing, Tamiesha, you're trying to get to is sometimes a parent will agree to a certain type of tutoring, and then they can't find it. They just can't find the tutor. And so you might have to go back to the school system and say, look, we can't find a tutor for X. Can we amend the agreement to make it a tutor for Y? Was it something like that?
Yes, it was something like that. Because one of the things that I, there was, I would say, like, assuming, let's say, you agree to individual tutoring, but then you can't really find a lot of individual tutoring programs, but you can find some group tutoring programs. Then you can probably go back and amend that. You can go back and ask for a specific type, or make sure that you have the fees at a negotiable rate. Make sure that you're paying attention to what the rate is that they're offering, or that you can be offered, because again, there's a standard amount that any program is going to offer you. But if there is an opportunity if those amounts were so accessible or easily accessible, then everybody would have the tutoring that they need. So make sure that you do your research on companies, and just on what the standard, what the standard rate for the actual, I guess, the state is, versus just trying to get, what's originally offered to you, because it's not easy to find.
I also wouldn't assume that the school system will go back and amend it. I mean, they might or they might not. But you want to try to avoid that if you possibly can, by making sure that what you're agreeing to at the time is something that you can access. But it's a very good point. If you can't access what you agreed to, and it's not going to cost the school system any more, then you should ask to amend the agreement.
I think the phrase I always use when I'm looking at, particularly in the comp ed framework, is useful and usable. Is this service something that's actually useful for my kid? And is it something that's usable to us right now? And I think the time frame point is a great point. I always like to tell folks, hey, if you have an idea of what service you might want to get out of this mediation, make sure you have a sense of, what provider you might want to use. Just so you have a sense, so you can do all the things that Tamiesha just mentioned. Know about the rates, know about the availability. Because it has gotten harder to find folks the last few years. It's gotten much, much harder. So where can you go to learn more? Hardcore fans of Special Education Thursday know this is where we always end with resources and information. We always have the IDEA Accessibility Project, which provides a nice breakdown of all of dispute resolution. We have a Know Your Rights document for dispute resolution. Again, when we post this, all of these links will be in the comments. I also want to flag Cadre's videos and family guides. They are not DC specific. So I just kind of want to put that little reminder for folks there, but they do have some very nice videos and handouts. And then our local Office of Dispute Resolution is housed within OSSI, and they have, a pretty comprehensive website that has a lot of information about mediation, including how to request direct mediation, and then also, who the potential mediators are, and some other just general information about it. All right, any final thoughts before we go on to have the rest of our day?
I think you should always go into mediation positive, and with a sense of the importance of what you're doing, and don't give up. That's what I always try to tell parents: never give up.
Perfect. All right, Tamiesha, here's your chance. Yay, mediation.
Well, just yay me. So I'm a big fan. I don't believe in, arguing if we all have the same common interest, which is the child, then I believe in mediation. Is just like my first choice. If I could always pick that for everything, then that would be my go-to. Just like you can contact all of these people in reference to it. I want to list myself as a source too. You can definitely give me a call or send me an email to Tamiesha.Lawrence@aje-dc.org. And my extension at 108-202-678-8060.
Okay, and as always, yes, As the federally designated parent training and information center for the District of Columbia, we remain always happy and delighted to be a resource to families. Thank you all so much. If you're interested in more dispute resolution issues, we do have videos coming up around going to hearing and also just, some of the things you need to think about when you're working with an attorney. But thank you all so much for being here. I'll put all the links in the chat and good luck.
Thank you, everyone.
Thank you.